Thank you all. Please be seated. This is a time set for oral argument in our case number CV220439, Weidert versus Precision Air and Plumbing, Inc. Each side is allocated 20 minutes for oral argument. Appellant, if you wish to use a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the podium clock. Out of respect for counsel and to avoid avoidable embarrassment, I would ask those in attendance to make sure your cell phones are off so our proceedings are not interrupted. Pardon me. We've read the briefs. We've conferenced the case this morning. We're familiar with the record. We'd encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted to YouTube, so please, as you begin oral argument, start by telling us your name and the party that you represent. With that, Mr. I'm going to mispronounce your name, and I apologize. With a name like Thama, you think I'd do better, but Mr. Mangdoth, is that close?
Yes. Well, it's close. Good morning, Your Honor. Your Honors. My name is Paul Mengadoth. I represent the plaintiffs and appellants in this case, the Keith and Diane Weidert. May it please the court. The Weiderts adequately in this individual and class action matter pled Precision came to their home initially to conduct a promotional inspection of their then working AC unit, which they saw as advertised on a television program prior to them calling and arranging for them to visit their home. Precision stated to Mr. Weidert during that inspection that the unit was working just fine, and that after he performed that inspection, Precision then set about to disable the circuit breaker to the unit and thereby broke that unit, the circuit breaker box to that unit. At approximately 9:30 p.m. that same evening, a second Precision technician visited the Weidert's home, and that technician again inspected the air conditioning unit, looked at and stated that to Mr. Weidert it could not repair the broken unit that Precision's first technician had rendered inoperable.
So, actually, the unit itself wasn't damaged, it was a circuit breaker?
It wound up that, according to a week later, a second unrelated business air conditioning repair company visited the home and determined that a mere $265 circuit breaker is all that was required to make the unit operable.
It seems like there's a claim in the case. I'm just concerned whether there's a claim in your pleadings.
Well, and Your Honor, I do believe that we adequately pled within the pleadings itself a number of violations of the Arizona Consumer Fraud Act. We're only going to be focusing on our appeal on the Arizona Consumer Fraud Act, and what we alleged is very specifically...
Why wasn't something, as common law fraud pled or breach of contract, perhaps?
Well, in this case, the facts were so egregious that it made it, and in a class action case, there would be individualized determination requiring reasonable reliance. Now, we chose and elected, because it was covered by the Arizona Consumer Fraud Act, as we adequately pled with the sufficient facts that were all to be in our favor, that Precision broke the unit. It's in paragraph 37 of the complaint. And it indicates that in the course of the inspection, it was part of this sales tactic and a practice on the part of Precision that was an act in the affirmative misrepresentation that there was a statement to Mr. Weidert that it would cost less to simply replace the unit than to repair it. And we believe that that was an individual claim that was adequately pled in the four corners of the complaint itself, as well as there were omissions of material fact both individually and to the proposed class as a whole. And that was that there was no providing of the federal mandatory right or notice of the right to cancel as a right, or providing a form of notice, as well as the non-disclosure of the Restocking Fee Act pre-contractual mandated disclosures.
Counsel, let me ask you a couple of just clarifying things, because you're getting to where I absolutely want us to have our conversation. There are 2 counts in your complaint, correct?
That's correct.
And both of them are under the Consumer Fraud Act.
Yes.
And for count 1, you had Arizona Home Solicitation Sales Act claim originally, but that's not part of the appeal.
That's correct. We're not appealing that part of the Rule 12C ruling.
And it was, as you point out, a motion for judgment on the pleadings, which is, a somewhat less invoked rule of procedure than 12B or Rule 56. Count 1, though, as I read it at least, alleges a violation of the Federal Trade Commission's rule. Fair?
Yes, it does specifically reference that.
And the FTC rule, let's talk about the FTC rule a little bit, promulgated in '72 by the Federal Trade Commission. Under the Consumer Fraud Act, courts are directed to look at guidance by the Federal Trade Commission. But help me understand why the FTC rule applies here, given that it seems to be targeted at door-to-door salespeople who initiate the call, whereas here plaintiffs made the first contact, at least, with defendants.
Precisely. The name is more or less non-descriptive of the full coverage of the Act. It need not be a door-to-door sale within the very definition of the FTC Act and the regulations promulgated under it in 16 CFR Part 429 is that it applies in the event that a consumer should even contact and invite them to the home in connection with the service, that would still require the mandatory notice of the right to cancel and providing a form of the notice of right to cancel.
In all purposes and everywhere, or in limited circumstances?
In circumstances that fit within the very broad definition that are supplied under the statute. It would be required for any amount of a good in excess of $25, and it would require, so it's not in every instance, so there's an initial analysis that's done, and it wasn't disputed or argued below that they didn't otherwise fall within the standard definition of a door-to-door sale. Rather, a particular very narrow exception was supposed to apply, and that was under 429.05. And in subsection 5, I'm sorry.
Right.
And so what we're looking at with respect to the exclusion here, we believe that the Superior Court on this unusual Rule 12C motion stepped in and acted as the finder of fact. And you have rather issues of material fact that are in dispute about that notice, whether or not it was even provided is contested in the answer, as well as so it's a contested issue of material fact.
Well, let me ask you about that. I read the trial court's ruling as saying that your clients didn't fit within the force of the FTC rule, therefore no notice was required, not a finding that the notice was somehow given.
I believe the court's main emphasis, though, in its minute entry, which was very brief, and it indicated it was focused on whether or not it was a replacement part or parts. That comes in only specifically with what Precision argued in the Superior Court, was that it was exempt under that exception to the general rule.
Right. And I think we're saying the same thing, maybe taking a somewhat different path to get there. I thought I heard you say that there was a dispute as to whether the notice was given as opposed to whether it was required under the law.
Oh, I'm sorry. It was in dispute in the pleadings. They disputed that they provided that notice. If you look in their answer.
And that may be, I don't recall the Superior Court going down that path in her ruling.
Okay, that may be correct, Your Honor. My apologies if I...
No, I just want to make sure we're understanding each other.
Sure.
Please proceed.
Very good, Your Honor. So there are, what is adequately pled, that the very next day of the sale, Mr. Weidert called Precision and canceled the purchase. The installation the following day was only tentatively scheduled, and therefore it was logically consistent that Precision informed Mr. Weidert that no technician had yet been selected to perform the installation the next day.
Why does that matter?
Because it was only tentative. The parsing out and the Superior Court's decision to say and recast our pleading as one requesting relief really for not a restocking fee, but instead a schedule of work fee, which was, if you look in the pleading, we didn't ever allege that.
So you're talking about count 2 now, not count 1.
Yes.
I just want to make sure I'm keeping up with you.
Yes.
And didn't your pleading allege that there was no restocking fee specified in the contract?
Well, there were really 2 contracts at play. There's a purchase and agreement, or quoted agreement form, and then there was a subsequent invoice.
Right.
And in both invoice and Exhibit B to the pleadings, it specifically states that there is a 20% restocking fee for canceled work.
Does it use restocking fee? I don't recall that.
It uses the exact language, restocking fee, and that was exactly consistent with what Precision later informed Mr. Weidert, that it was charging him a 20% restocking fee. It stated that to him on the telephone. It further, which Precision admitted in its answer, it subsequently, when Mr. Weidert made a dispute of the entirety of the charge, it claimed that to the credit card company that it was actually a restocking fee.
Well, and the answer takes inconsistent positions, right? In one instance, it disputes restocking, in the other, it admits, right?
Correct.
As a factual matter.
As a factual matter.
And then the question is, legally, is that a restocking fee, correct?
Correct. And we believe that it is. And
I understand that and I want to hear more on that.
Okay. So with regard to the restocking fee, in and of itself, the restocking fee, as argued below, it's under 1377, there was a restocking fee act, as we call it, and it requires a number of actions and disclosures, both on the credit card receipt as well as posting of some notices, and it broadly requires the disclosure on for any product a business sells, the existence of the fee and an amount of the fee to the consumer in accordance with the Restocking Fee Act. And
I'm going to stop you just a minute because I'm glad you brought that up because, and again, I could be misremembering this, but my memory of the contract language was it did have the language about the restocking fee that you're talking about, but the sentence before that had a sentence about cancellation and that it would be a 20% charge for cancellation. So are you saying that that was not adequate enough for the cancellation fee that they charged?
Correct. Under the Restocking Fee Act, it would not be. Just merely placing it there, there's a whole host of requirements under the Restocking Fee Act that just...
And I understand that, but I'm talking about the cancellation sentence that said that, you know, there would be a 20% cancellation fee, and then it talks about the restocking fee. So there's two clauses in that paragraph. One talks about cancellation and one talks about restocking. So I understand your arguments about the restocking fee, but I mean, there's also a sentence that said there would be a 20% cancellation fee. So my question is, are you arguing that both things didn't provide adequate notice to your client?
Well, essentially, that we made the argument that it was on a Rule 12C motion to make a determination one way or the other. We pled adequately under Rule 12C that it was a restocking fee. And we didn't plead that it was a cancellation of work fee anywhere within our pleading. So that's a matter to be determined and sussed out, allowing for us to have discovery on that issue, which the Superior Court did not permit.
Counsel, can I ask you on that, and I'm just reading because I'd written it down, the contract again, not the invoice, but the contract, and I'll quote, references, quote, cancel any scheduled work, there is a 20% non-refundable charge, close quote, and then later, quote, there will be a 20% non-refundable amount for all scheduled work, close quote. That's what you're saying is the restocking fee?
We're saying that the 20% for scheduled work is the restocking fee.
Okay.
Correct.
And then what I'm struggling with as well is the definition of restocking fee in the statute. A business fee charged by business for restocking the good purchased on its return or exchange. What did your pleading allege was returned or exchanged?
And I see I have 5 minutes, may I answer the question?
Sure, yeah.
Your Honor, what was, the act itself does not state it has to be delivered. The act itself, the Restocking Fee Act does not state it has to be delivered or it has to be purchased. That would be inconsistent with what are pre-contractual disclosure obligations.
Well, and I guess what I'm focused on is return or exchanged.
And in this case, there was a cancellation before any product was delivered to the home. That's correct.
Okay, thank you. Thank you. And again, continuing my inability to pronounce, Mr. Janasek, is that close?
You nailed it, Your Honor.
Okay, thank you.
Not easy to do. Doug Janasek, on behalf of Precision Air and Plumbing. May it please the Court. The trial court correctly dismissed this action because the laws on which the Weiderts base their consumer fraud claims do not apply on their face. The trial court's ruling was one of statutory interpretation, and it properly accepted as true all of the complaint's allegations. In the end, the problem for the Weiderts is that while their allegations may give rise to a simple breach of contract, which they chose not to bring, they do not trigger the Consumer Fraud Act. Alternatively, if this court were to conclude that any part of the Weidert's consumer fraud claim is viable, this court should at least affirm the trial court's finding that any such claim cannot go forward as a class action. Individual issues of reliance, a prerequisite to recovery under the ACFA as a matter of law, predominate.
Counsel, let me ask you on the class action, because that was an alternative holding, and I want to keep that in mind as we use our time today, but is reliance required under the Consumer Fraud Act?
Absolutely, Your Honor.
What's the best case for that? Because it's an implied cause of action. I mean, we're working on a somewhat different sort of mechanism than we might typically where there's an express cause under a statute.
Your Honor, all three of these cases, Correa, Kuhn, and Parks, all cited in our brief, state that in a private claim under the ACFA, not one brought by the Attorney General, but
right.
One brought by a private plaintiff, they must show consequent and proximate injury. And then in Sanders v. Harris, 2021 Westlaw 282261, this court addressed an omission case. The argument that the Weiderts make, it's important for the court to understand, they don't make any argument about class certification, whether individual issues would predominate. Their only argument is reliance is not required.
Right.
So they don't go, if reliance is required, they've conceded that this would splinter into thousands of trials. But on an omission case, this is their argument. They say it's not required for an omission case as opposed to a misrepresentation case. Sanders v. Harris addressed that directly. That was a failure to disclose material facts, defects in connection with a home sale. This court first said, yes, the ACFA requires only the intent that others rely on the alleged omission, but not the intent to deceive. But the court then went on and said, quote, to succeed on their consumer fraud claims, plaintiffs needed to prove defendants made a misrepresentation or omitted a material fact, and they suffered damages as a result of reliance on the misrepresentation or omission, close quote. I do want to note that the Arizona pattern jury instructions really mirror Sanders' Commercial Torts 21 consumer fraud, the Raji. Paragraph 3 says, plaintiff, this is an element of the proof for the instruction, the plaintiff must show that he or she suffered damages as a result of reliance on, and it's a series of actions by the defendant. It says deceptive, unfair act or practice, fraud, false promise, misrepresentation, concealment, suppression, or omission of a material fact. So that's right out of Raji.
Thank you.
You're welcome, Your Honor. Let me proceed. I just want to make clear, the counsel stated that they pled a claim involving what I understand to be an intentional breaking of the unit as part of a scheme for the second technician to come out and sell a replacement unit. That is absolutely nowhere in the complaint. As Your Honor pointed out, the two claims are for violations of the ACFA based on notice provision. That's all that's in the complaint. And even in the opposition to our motion for judgment on the pleadings, this theory never showed up. The only place I've seen it is in the reply brief before this court in footnote 1, where they say, we do dispute whether that act was intentional and part of a sales scheme. That is not a cause of action that exists in this case. So with it being a notice case, and as Your Honors pointed out, they have dropped the HSSA claim. So that leaves the FTC rule. Now, I want to point out that there is an important exception to that rule. There's an exception for buyer-initiated calls for the purposes of repairing or performing maintenance upon the buyer's personal property. What the judge held here as a matter of regulation interpretation was that performing maintenance encompasses inspecting a unit. That's just in ordinary common language. That's what it means. It's different than repair. That's why it says repair or perform maintenance. And even if there was a question as to that, the invoice that the Weidert's attached to the complaint, which this court can then consider, if you look at the invoice from the first technician, Justin, this is the maintenance work he performed. 36-point diagnostic evaluation, condenser coil cleaning, condensate drain line flush, 1 permanent washable air filter. That's not just an inspection. That is performing maintenance. So once we trigger the exception, it goes on to say that it does not apply, so it's an exception within an exception, but so it does not apply if the seller buys the right to receive additional services or goods, okay, other than replacement parts necessarily used in performing the maintenance or in making the repairs. Well, a full unit replacement qualifies as necessarily used in performing the maintenance or making the repairs. That's what the Superior Court held, a very common sense definition.
Counsel, let me ask you, in the commentary to the FTC rule, there's reference to, repairing a furnace and then selling a furnace, and that those are treated differently. What's your response to that?
Let me address that directly and then a couple side points as well. That remark, when you read that whole comment in context, all that means is if you're installing a new furnace, you can't sell that new furnace. Let me rephrase that. You can't sell a new furnace without complying with the rule, okay? But what that means is if the buyer does not contact the seller for maintenance or repair of that furnace, then you have to give the 3 days notice. But that makes sense because in that situation, the homeowner is not prepared to address or discuss the furnace. They are being blindsided by a sales pitch for, hey, looks like you need a new furnace. The whole exception exists because the pressure of door-to-door sales is not there when you call the vendor and say, come out and work on my furnace.
But how is that different than here? Because we've got a couple who called them out, and I'm not going to dispute whether it was, for an inspection or service, but they're there, it was working before they got there, and now it doesn't work, and it's in the middle of summer. How are we not in a situation where they kind of are stuck and relying on your client to tell them, hey, this is what's going on and we can fix it, when ultimately what was found to be the problem, and again, this is a question of fact more than of law, but that it was a circuit breaker.
Well, the problem, though, Your Honor, is this is not a claim based on false representations that you need a new unit. What was pled was failure to put in the contract a 3-day notice cancellation period. They canceled. So actually, while that may be an issue in another case, it's not here because what they pled was the violation was not putting the 3-day notice period in the contract, but they cancel it anyways. There's no allegations of fraud in the sales pitch from the second technician. That only shows up in the reply brief. And I would point out that that's part of the concern. If you look at the page that they cited from the Federal Register, that was part of the concern of the FTC, was that in situations where people needed something, if it's part of that exception where you're coming out to do maintenance or make repairs, if you had to install a new unit, you would wait 3 days then. It would actually cut against the consumer because a lot of sellers would say, if I can't take advantage of this exception, which exists for maintaining or repairing home units, then I'll wait 3 days before I replace whatever's not working. So the FTC, if you read that commentary, that was their concern. That's why they put in this exception, so that homeowners would not be stuck waiting 3 days before the seller would actually do the work that's needed.
Let me ask, it seems to me that FTC rule, as I read count 1, and given that the stocking claim is gone on appeal, it's the violation of the FTC rule. Either it applies and was violated or it doesn't, but that's count 1. Do you read it differently?
No, Your Honor, that's how I read it.
And as I read the commentary for the FTC rule, the primary concern, wrong. There were several primary concerns that the commission identified, but one significant one based on complaints was literal door-to-door salespeople that would overpower the will of homeowners once they were able to engage with them. Here we have a homeowner contacting Precision Air, but then also we have 2 visits to the home. Does the fact that 2 different technicians at different times, both I think at the request of the homeowner, the pleadings would indicate, visited, does that have any import in what we're doing here?
I don't think it does, Your Honor. In fact, to highlight the door-to-door sales aspect of these acts, the HSSA under Arizona law, in direct sellers v. state, our Supreme Court pointed out that this law, as a matter of state law, is regulated to that door-to-door sales. So that's why that claim really had to be abandoned. I mean, there is no state law requirement to include a 3-day cancellation period in this case. There just was no door-to-door sale. But even under the federal rule, I don't think it makes a difference because, again, the whole point is if you were contacted to come out to either perform maintenance or repair a unit, then the homeowner is prepared to deal with that issue. There's no blindsiding, there's no unexpected sales pitch. That is part of the protections that the rule provides. So I really think that the commentary actually, again, when you read page 22947 that they cite leading up to why they put this exception in, it's so that homeowners could get prompt relief in terms of repairing a unit. So I think the fact that there's 2 visits doesn't make a difference.
So there's a difference in coercion and persuasion then, whether you see, and I heard someone knocks on the door, and I don't see why that necessarily as a practical matter makes a difference. That's the reason they put the ads on TV is to encourage people to call. The door-to-door salesman knocks on the door to get you to answer the door so something can be sold to you.
I agree. Now, that's only an issue, again, under the federal, under the state rule, which, again, is not on appeal. Our Supreme Court has said it is about door-to-door sales. Now, Your Honor, you're bringing it up with the FTC rule. That might be a concern, but that's the language of the exception that they put in the rule. And I do want to point out that there are a couple cases, they're not Arizona cases, but we cited Smaldino v. Larsick from the Ohio Court of Appeals and Lotto v. All-American Pools from Connecticut. Both cases involved a homeowner who contacted a vendor to come out and work on something in their home. In Smaldino, it was a furnace. In Lotto, it was their swimming pool. And in both cases, additional work was done once the technician came out. In Smaldino, it was actually a replacement of the furnace. It's exactly this case. They went into the heating chamber and realized this whole thing is gone and we need to replace it. And the Ohio Court of Appeals applied that exception to the FTC rule.
And counsel, let me ask you one question, and then I'd encourage you to turn to count 2, because we'd like to hear from you there as well. But the FTC rule, including commentary, is a guideline for this court, right? It is not necessarily the equivalent of being within the Consumer Fraud Act itself.
That is correct, Your Honor. And as we argued in our brief, really what the Weiderts are trying to do is take what is an otherwise non-existent Consumer Fraud Act claim under state law, because there is no 3-day requirement in this case, so there can't be a material omission, and use the FTC rule to create that cause of action. It's only a guide, but the scope of the CFA is a state law issue. It's not a federal issue, so really that's what they're doing.
And let me ask then, as we turn to count 2, because the answer both disputes that it was a restocking fee and then admits that it was a restocking fee, and there was no amendment of that pleading, and so here we are.
Let me address that, Your Honor. It doesn't matter what I say a restocking fee is, it doesn't matter what the Weiderts say it is, and it doesn't matter what Precision Air employees said it is. What matters is what the legislature says a restocking fee act is, or what a restocking fee is. And the restocking fee, and this is exactly what Judge Gates held, it is for the restocking of the good purchased on its return or exchange. And if you assume everything that they allege is true, which is what Judge Gates did, this is not a return or exchange of a good. Nothing was ever delivered, and as they say, nothing was even scheduled. So it's a legislative definition. They could have said cancellation fees are subject to this statute. They could have included that word, but they didn't. It's very specific language. And so given that there's no return or exchange, the act simply doesn't apply under all the facts, assuming all the facts are true that they've alleged. I'll just wrap up. I'm happy to answer any other questions.
I do have one more
Yes,
question,
please.
and it goes back to the question I asked co-counsel or the other counsel. In that paragraph in the contract that has the one sentence about the cancellation fee and the one sentence about the restocking fee, is it your position that there could potentially be both. There could be a 20% cancellation fee and a 20% restocking fee. Or is it either or?
I think with the way they defined the act to be a return or an exchange of the good, I think you're probably dealing with an either or. I mean, there may be situations where both would apply, but the important point here is that it's two different charges. And so to the extent that they just generally attack the 20% charge for cancellation, it's stated twice in the purchase contract. It's stated in the invoice. There's no defense if the Weiderts didn't read it. That's not the law. And I do want to point out, they actually never alleged that they didn't know about the 20% cancellation charge. They only alleged that Precision Air didn't tell them about it. But that's not required when it's plainly stated as it is in the contract. So again, I think that clearly spells out two separate fees, and the Restocking Act only goes to that second one, return or exchange, and that's just not this case.
Thank you.
I do have 50 seconds. I'll wrap up quickly by saying, I know at the end they suggested leave to amend. Our position, it is far too late for that. They made a vague request in front of Judge Gates, but that had to do with the installation, paying a credit card debt in installments, which was under the prior Arizona Act. And so that is now out of the case. Nothing else was said below in terms of what they could add. And here, even in their opening brief, there was really no basis at this point to allow an amendment. Nothing was explained as to what they could possibly add that would change the meaning of these laws. Thank you.
Thank you, Counsel. Rebuttal.
Your Honors, respectfully, I'd like to take 4 key issues with respect to the argument of appellee and address them now. The first is what you hit upon on whether or not reliance is necessary. As this court and Your Honor himself specifically referenced, this is an extraordinary issue that you all too often do not see, where we're dealing with a Rule 12C motion for motion of judgment on the pleadings. And with respect to all of the cases, no matter what they say and what they conclude or the facts within them, never confronted a Rule 12C motion. And I'd ask the court to look at the plain meaning of what is set forth under the Arizona Consumer Fraud Act. Both the Acts section, which our Supreme Court in in the AutoZone case, parsed out between an Acts provision clause and an omission clause. And I think that that's where there is a tremendous amount of confusion in the courts and some of the opinions, because they're not sussing out what is alleged and how it's alleged. And that's led to confusion, and why we urge the court for a written opinion in this case, because all too often there's an overlapping of notions of reliance. If you look to the omission of material facts, the omissions clause, you'll see that it's the intent of the speaker for the hearer to rely. And therefore, that doesn't require an addition of, in that clause, of, and the hearer justifiably relied. That's not within the Act. In the affirmative misrepresentation cases, that is argued to be a part of the requirement in certain instances. Under that Acts clause, it's not only deceptive or affirmative misrepresentations, but deceptive acts. And what we argue here, and I think we adequately pled, and to the extent, like counsel mentioned, we did request leave to amend. If this is omitted in some fashion and isn't what the court concludes to be a reasonable inference to be read in our client's favor, that no one, when they're told that it would cost less to buy a brand-new unit than simply to repair it would go forward with that transaction. So to the extent that Precision argues in its brief, we didn't make that allegation. I think it's pro forma, but we asked the court leave to amend to do that. And I believe leave to amend ought to be given freely as justice requires, and this is the case.
One quick point. You did not make a written motion to amend with the red line to pleading, right, in the trial court?
That's correct, Your Honor. We noted it in our brief, in our response, as well as in oral argument. So with regard to reliance, with just 1 minute left, I do want to hit on the notion that the Restocking Fee Act is what is so constricted in the notion of how a restocking fee is considered and whether a violation occurs. Defendants themselves, the Precision, specifically told Mr. Weidert this was a restocking fee. So as to whether...
To follow up with what Judge Foster was saying, a sentence before talks about a cancellation fee. So when you're talking about a cancellation fee or a restocking fee, practically speaking, what difference does it make in terms of what money has to be laid out?
And what I believe the Restocking Fee Act would require, it's both. It really is a 20% upcharge for if you cancel, we'll charge you a restocking fee and under the terms of the contract, and it's a restocking fee and it's a cancellation of service fee, both which are absolutely outrageous fees for never ever delivering a good and and to replace a good that a business broke.
Counsel, thank you. Time does go quickly. We appreciate your written filings. We appreciate your oral argument today. You've given us much to think about. We will take the matter under advisement and we'll issue a written ruling in due course. This version or this case now is recessed. We will stay on the bench while we set up the courtroom for our next oral argument. Thank you very much.